This is Sivana. Where it is? Just stay Sivana. Sivana. Sivaganam. This is Sivana. Ah, yes. I request what is this? Hello?
Honorable Mr. Justice S.K. Kaul, Judge Supreme Court of India, Honorable Justice M.M. Sundaresh, Judge Supreme Court of India, Honorable Mrs. Justice Bella Trivedi, Judge Supreme Court of India, Honorable Mr. Justice Ashutosh Kumar, Judge Patna High Court, Honorable Mr. P. Wilson, Senior Advocate Member Parliament Rajya Sabha, Honorable Mrs. Lubna Shuja, President, Law Society of England and Wales, UK, Nishit Desai, Senior Advocate, High Court of Bombay. In this grand orchestra of legal minds, the International Lawyers Conference 2023 is a crescendo, a momentous event where the legal luminaries from around the world are gathering together, harmonize their perspectives to exchange wisdom and to fine-tune their understanding of the interest of the international law. Just as symphony unless unites musicians from various backgrounds, this conference unites legal practices from diverse legal traditions. Now there are the judges of the Supreme Courts and High Court and senior advocates address this working session, Global Law for Global Issues. Now I am requesting Mr. Ranjan Jha, Member Bar Council of Bihar, present a memento to the Honorable Justice S.K. Kaul. Justice S.K. Kaul. A flower. Present a bouquet to Honorable Justice S.K. Kaul. Now I am requesting Mr. J.J. Patel, former Chairman Bar Council of Gujarat, presenting a bouquet to Honorable Justice M.M. Sundaresh. I am requesting my esteemed member, Mr. Manoj Kumar, Vice Chairman, Executive Bar Council of India, present a bouquet to Honorable Mrs. Justice Bella Trivedi. I request Mr. S.C. Srimali. Srimali is there? Mr. Srimali? Yes. Mr. Vishnuvardhan Reddy, present a bouquet to Justice Ashutosh Kumar, Judge High Court of Patna. Mr. Dilip Patel, Member BCI, present a bouquet to Honorable Mr. Wilson. Dilip, jaldi आओ. Yes. Wilson, Mr. Wilson. Presenting a shawl. Then last. I request Mr. Rami Reddy, presenting a bouquet to Lubna Shuja, President Law Society of England and Wales, UK. Lubna Shuja. Mr. D.K. Sharma. I request Mr. D.K. Sharma, present a bouquet to Nishit Desai, Senior Advocate, Bombay High Court. I request Mr. Manoj Kumar, present a bouquet to Mr. Adishya Agarwala, President of the Supreme Court Bar Association. Now this time constraint, I am handing over to, presided over by the Honorable Justice S.K. Kaul. Sir, you can take a charge, sir, please.
Can you hear me now, please? Yes, okay. Brother Sundaresh, Sister Bella Trivedi, honorable members on the dais, my brother judges, brother and sister judges, the members of the Bar Council members and representatives, President of the Supreme Court Bar Association, ladies and gentlemen. So, let's begin the first session with the conspectus of what we are seeking to discuss. It refers to global laws for global issues. If I may say so, it's a huge spectrum which has to be done. There is, of course, the fact that the globe is one globe. We have one earth to live on. We have different norms in different places. As time has gone by, there are certain commonalities which were discussed. And with world becoming smaller in terms of interaction, economic activity and other factors, it is necessary to find some common ground in various areas which concerns all of us collectively, even given our diversity. I'm just initially going to flag some of the issues which arise for consideration and leave it to the other panelists to comment on the different aspects of it or any other aspect which they think would be relevant for this purposes. I think one of the first issues I would like to flag as a global perspective is the environmental crisis facing the world over. No one country can find solutions to this problem. Reminded of Mahatma Gandhi's quote that nature is enough for everyone's need, but not for every man's greed. The bone of contention when it comes to combating environmental issues is divided somehow between the interest groups of the North and the Global South. The reason being that there is a perception among the Global South that the more developed nations over a period of time are utilizing the Earth's resources much more, and because of underdevelopment, certain other sections of the world were not able to get the benefit. So in the balancing, the issue is do we sacrifice equally? Do we sacrifice depending on how we have in the past utilized the resources of the Earth? And this has resulted in a debate and multiple agreements around the world, including the Declaration of United Nations Conference on Human Environment, the Rio Declaration, the Paris Agreement. But the proof lies in its pudding. So issue is how far the different nations are able to restrict their personal interests for this larger issue to determine that we have so far one Earth to live on. We don't know about the future. Accountability in such a situation plays a major role. A large number of the pollution countries, when it comes to imposing restrictions, the Global South, in a sense, faces the brunt, which is what I referred to foresight. And how to balance this out is a great challenge. In the context, India's targeting of decarbonization by 50% by 2030 is laudable. If India has to play a role in the world as it seeks to do, then certainly environmental issues will also have to be flagged as one of the issues where India will have to play a leading role. Technology has grown over a period of time. Technology has brought in its positives and own negatives. So we have the issue of cyber threats, cyber crimes being transnational. And there are no boundaries between nations on this issue. In fact, some nations are more active in propagating it also, if one may say so. So it becomes an international competing area. Cyber warfare deserves much attention. In future, the concern is that if wars would arise, it's not necessarily man-to-man combat which will arise, but it will be a combat between technologies which would arise. With a few exceptions of the Budapest Convention on Cybercrime and African Union Convention, which is in force, the law on this area is still at a very nascent stage. And due to this novel nature of threat, debate certainly requires to be carried out across the world on the laws on cyberspace. The main issue which arises here is the multiplicity of stakeholders, as most of the cyber activities take place on platforms that are not necessarily state-owned. And so the balancing, accountability and oversight becomes more difficult. But the silence on this issue is frightening, actually. This is evident that without tailor-made laws, customary international principles and practices, this is going to be a huge, huge problem. So the world leaders need to take note of it, to develop some common protocols, how to tackle this emerging problem. It should not be the problem faces us and then we start developing it. Even the countries which have taken position on this issue have had certain disagreements, and challenging the availability of international humanitarian law, the right of self-defense, duty of due diligence, right to take countermeasures with respect to online activity are all issues which need to be flagged. A possible solution, which I may say so, is a multi-stakeholder consensus, paramount to solve this issue, which involves solutions from both the private players as well as public sectors. The question to be pondered would thus be that whether we are saving the state from citizens or the citizens are saving the state. Coming to international trade disputes, on international level, we are now much more geared on this issue because we started thinking earlier how to tackle the governing issues of trade dispute in international trade law, which aims to regulate state governments' business policies. The private part is also regulated by cross-border business dealings. Any business activity naturally will result in some disputes, some difference of perceptions. And thus, the dispute settlement mechanism in this sphere is comparatively well established. India has played a role in it, and with, I think, the Mediation Act coming into force, we'll see some movement on this issue, both on the international level. But the dispute settlement mechanism has its roots stemming back to the formation of the GATT. With the establishment of the WTO, there have been discussions on whether to continue, modify, or terminate such dispute settlement rules and procedures. As per the United Nations, the Dispute Settlement Understanding Review is currently being carried out within a framework of 12 thematic issues covering a broad range of proposals. But a lot needs to be done. We have not come to a finality on the issue. My view would be the current set of treaties should also be modified in a manner that suits the interest of the developing countries. While free trade is welcome, the financial resources often are ignored when drafting the treaties. And thus, the more developed nations will have to play a more positive role. And as India moves towards a development strategy to play a role as a more developed nation, its role will increase and will have to be more positive in a leadership role. Turning now to the human rights violation. After all, the earth is occupied by the humans. It has cost some other species more. And the human rights violation within itself is there, and there's also an aspect of violation vis-a-vis the other species. That's why they say the human race is possibly more selfish. It has to learn to live with the other species which exist on this earth, which the God created. And that disturbance of that balance has its own challenges. The other is the aspect of human rights carried out by, in a violation manner, by humans themselves. And the inherent and intrinsic to each individual is factors such as race, creed, caste, sex, nationality, and the right to life and liberty, freedom from slavery and torture, freedom of opinion, to name a few. Everyone is entitled to the rights without any discrimination. Therefore, the international human rights law. There have been various treaties on this aspect, but the world is going through a difficult phase at the moment, divided over what different perceptions are. In fact, this is a great challenge, I think, within a country and outside a country on the international level. How to accept difference of perceptions and find a solution which is acceptable to all sides. I think the whole concept of the world being one is something which needs to be emphasized, because one part of the world can't exist without the other. One species cannot exist without the other. The implementation of basic human rights requires diplomacy at the highest level and an endeavor to find solutions to this problem. Lastly, turning to the issue of insolvency. With growing trade and cross-border transactions, the need for a unified insolvency law has been in demand. Framework is provided by the UNCITRAL legislative guides on insolvency law, EU regulation, insolvency proceedings, and Strasbourg Convention, amongst others, such as legislations, are stepping stone towards taking cognizance. The Indian law also, with the new insolvency code, seeks to address part of this thing, but on the aspect of across the world, insolvency and cooperation, still that chapter needs to be addressed. The approach towards tackling this is largely divided into two concepts, which is territorialism and universalism. The problem with the first approach is that depending on the forum, the law applicable to recognition and enforcement of foreign rights claim may differ. The UNCITRAL legislative guide is unlike any other multilateral convention. It merely provides a legislative guide to modify their laws to ensure a consistency on insolvency laws and practices. The effective implementation remains the issue, and that's an issue within the country also we'll have to address. To my mind, these are some of the topics, not exhaustively, which deal with aspects when we look at an international platform, how to deal with these issues. We have an eminent and large panel, but we have also a shortage of time. So I would, at the earliest, request all my panelists to be as brief as possible so that we can get some time for interaction also, depending on the time which remains after that. May I now request Justice Sundaresh to give his opinion on the subject.
Thank you. More than 1,000 years ago, a very powerful statement has been made by a poet in Tamil Sangam literature. He said, which I quote in Tamil, Yadum Ure Yavarum Kelir. The entire world is mine, and everyone who lives thereunder is my relative. Edgar Mitchell, the sixth person who landed on the moon, made an interesting comment. He said, from out there on the moon, international politics looks so petty. As Justice Kaul has said, the topic today is so huge. How do we define a global issue and therefore a global law? Are we to confine our understanding to different nations? Or are we to look at humanity as a whole? With the demography changing and the migration of population from one place to another, we need to understand it with a different perspective, as what we think today may not continue tomorrow. It may be a wishful thinking. You have countries having different ideologies, but humanity as a whole has its own issues and problems to be dealt with. Therefore, in my considered view, when we talk about a global issue, we need to think so broad to include problem faced by people from one place as against the other. Once we draw this conclusion, then, as Justice Kaul has said, how do you deal with the issue of environment? Number one. how do you deal with other issues touching upon civil rights and cases pertaining to criminal law? Hubert Reeve made a very fine statement on the human species. He said, human beings are of the most insane of all the species. They worship the invisible God while destroying the visible nature, not knowing the invisible God he prays is the nature he destroys. When we understand the environmental law on a global perspective, we cannot confine to a particular state or a particular country. The idea is to have a good environment throughout the world. This goes to the developed country also as against underdeveloped countries. Therefore, this mindset has to change. Now, what is the framework we have to deal with this? Which I will put it to the distinguished speakers to give their perspective about it. We have conventions, we have biodiversity treaties, but what is happening on ground? Can we say that environment in a particular state requires to be protected at the cost of environment in another state? It can never be. For the flora and fauna, for the animals, migratory birds, entire world belongs to them. That is one part of it. And he also flagged about IBC code, and it had need for international code on insolvency. Now, already we started moving towards it. Most of the new enactment, particularly on the commercial field, starting from IBC code, Arbitration Act, we have followed universal principles widely accepted across the countries. Once we do that, it becomes more of an international and therefore global issue. When you deal with a party who comes from the other side. Now, this can be stretched. Can it be stretched to personal laws? I would say yes. What is the problem? How do you deal with the problem? An issue of divorce, an issue of custody, an issue regarding property between two partners, one belonging to some other country and another belonging to the country like India. Therefore, the personal issues would also attain a global perspective. And so also for the corporate entities. Time has come for us to think aloud, as in the inaugural section it has been spoken about by the Chief Justice of India. We need to think broad. We need to think about the future. We need to evolve new laws, both internally, which is also inclusive of criminal law, though we follow Indian Penal Code, substantially borrowed from the British system, Evidence Act, Code of Criminal Procedure, and Civil Procedure Code. But structural changes are required to deal with the problems, not only the local problem, but problems touching upon citizens belonging to the different countries. With these few words, I thank the organizers for giving this opportunity. Thank you very much.
I would now request Sister Bela Trivedi to share her views.
Good afternoon, everybody. Dignitaries on the dais, off the dais, invited guests, and friends. I know that eminent speakers are there to speak on the subject, but since we are also supposed to express our views in few minutes, so I thought let me jot down my few views and I'll present them. First of all, I would congratulate and compliment the Bar Council of India and its collaborators for organizing such a wonderful event on very vital issues, global issues. They are vital because global issues are nothing but the issues of individuals only. As we know, the universe is one, and the fundamental law of universe is the law of divine oneness, which says every thought, every action, every event beyond our senses is some way connected to anything and everything else. Everything in the universe is in constant motion, and every motion has a vibrating energy which has corresponding ripple effect. So whatever happens in the universe ultimately touches to the individual being also, directly or indirectly. And therefore, someone has rightly said, as above, so below, as within, so without. Justice Sundaresh quoted a quote of one astronaut. I'll quote another. Sirisha Badla, the third Indian origin woman to become the astronaut after Kalpana Chawla and Sunita Williams, she had reacted in an interview after her ride to almost 90 kilometers above the Earth in July 2021. She said, looking at the Earth and seeing the thin blue line of atmosphere really brought me a perspective of how lucky we are and how fragile our planet is. It was incredible to see. I was looking out at the southwestern part of the US. We talk about states, but I saw no borders. And it put me into a perspective how divided we have become. And seeing brilliant Earth against the mad black void of space made me feel small, but not insignificant. So I returned to the planet, energized to pursue positive change for good and really appreciative of what we have. So in this era of globalization, the paradox is, though the political maps show boundaries between the countries, those boundaries disappear when it comes to competitive maps. The globalization, which has integrated the economy of one country with the global economy, and in turn allowed free flow of information, technology, goods and services, capital investments, has in fact created a borderless world. There is a paradigm shift in the world market from the traditional trade activities to a high-tech global trade and commercial activities. The use of smart contracts, the use of blockchain in the cryptocurrency systems have brought massive transformation in the world trade market. I would highlight cryptocurrency system because it has become a very game changer in the sense that cryptocurrency, which is also a digital asset, though is not considered to be a legal tender, is functioning as a medium of exchange akin to money. Since cryptocurrency does not have any legal tender and there is no regulatory authority in place, it is easy to trade between the countries. The nations are still grappling with the new world order of financial activities as to how to regulate digital currency, which has the tendency to be used in illegal activities and in turn misuse of financial systems for corruption, money laundering, terrorism, proliferation of weapons, and mass destruction, and of course, environmental issues also. Corruption and money laundering have wide-ranging impact on the nation's political, social, and economic development and stability. Such illegal activities have emboldened the organized syndicates and the terrorists. Corruption, that is bribery of or theft of public funds, is generally committed for the purpose of gaining illegal funds. And the activities of money laundering are done mainly to conceal those illegal activities. Today, the New World Order is also grappling with the proliferation of terrorism, armed conflicts, confrontations, and power struggles, which have led to problems of varied dimensions. Though international humanitarian law is part of the public international law, it has failed to attract adequate attention of the states and the international organizations. The environmental degradation and climate change, which have already been dealt with by my previous speakers, and I'll cursorily go through, have also entailed serious threats to the global community on the planet's ecological balance, human well-being, and sustainable development. Much has been debated, much has been deliberated upon, and much has been acted upon also. But the climate change and the environmental degradation have continued to pose serious threats to the planet Earth, impacting ecosystems, economies, and human security. The climate change is also significantly impacting the world's oceans. The high seas, the areas beyond national jurisdiction, cover almost 2/3 of the world's oceans and are home for diverse ecosystems and species. Legal framework for addressing climate change in the context of law of the seas are still evolving. The law of the space is also at the crossroads, facing numerous global issues that require careful consideration and international cooperation. As the number of satellites and spacecrafts in the orbit continues to rise, effective space traffic management is essential to prevent collision and ensure the safety of space operations. A lack of coordination can lead to close encounters and increase the risk of accidents. Unlike public international law, private international law has the framework that serves the guiding compass in the world, where the legal jurisdictions of the states often overlap and the boundaries of national sovereignty blur. Private international law dwells into the issues spanning multiple countries and encompass aspects like inter-country adoptions, international commercial transactions, human trafficking, etc. The International Institute of Unification of Private Law and other international organizations have streamlined the treaties, model laws, and other tools to control the domain of transnational conflicts, and in addition to the regulation established by the national authorities. Lastly, I would say we do have various global organizations working very actively and effectively in shaping and resolving the issues pertaining to the public and private international law. But they all work in silos and not in tandem. They do not intersect, they do not collaborate or work in cohesive manner. So what we need to do is to have a robust framework for addressing cross-border legal issues. The nations will have to continue their efforts to harmonize the laws and to create efficient and effective mechanism for the recognition and enforcement of foreign laws and the judgments. Thank you so much. Thanks for giving me this opportunity.
Justice Ashutosh Kumar from the Patna High Court would next share his views.
Thank you, sir. Honorable Justice Sanjay Kishan Kaul, Honorable Justice Sundaresh, Honorable Justice Bela and Trivedi, Honorable Judges of the Supreme Court, Mr. Wilson, Senior Advocate, Lubna Shwaza, President of the Law Society of England and Wales, Mr. Desai, Senior Advocate, Bombay High Court, Mr. N. Koteshwar Singh, I see in the audience, Chief Justice of J&K, Dr. Anita Sumant, Justice from Madras High Court, my friends, advocates from different states, members of bar councils of different state chapters, and I see many from Bihar as well. Well, very good afternoon to all of you. Justice Kaul reminded all of you about Mohandas Karamchand Gandhi's statement that world has everything that the mankind needs, and the world would be deficient for the greed of mankind. And Justice Sundaresh says, he quotes from a very famous poet's couplets, says, world is mine and all are my relatives. I think the global perspective lies somewhere in between. Schumacher, one of the philosophers, he said that the world is small, world is flat. Now he was very, he was thinking in future. World definitely is the globe today is very small. It can be traversed, it can be accessed by anyone in no time. See, what is the purpose of globalization? What is the purpose of a law which looks at global issues? What is the difference between globalization of law and globalization in law? These are some of the concepts which would be readily answered if we see what has been happening all these years. Not that it is a new concept. We are not writing something on a new slate. It has been in the past the experience that with the efforts of world leaders, the nations, when they have walked and have kept pace with the stride of the world, the resolution has come forward. See, in our increasingly interconnected world, the global issues require global solutions. This is the topic today. International law plays a very pivotal role in addressing these challenges by offering a framework through which the nations can cooperate to tackle common problems. The debate today, and rightly so, is whether national states can effectively regulate phenomena which are intrinsically global in nature, such as climate change, immigration, human rights, food and health security, etc. With the coordination amongst nations, these issues can be handled in a more comprehensive and sustained manner. Justice Trivedi was right when she says that if nations work in silos, perhaps no more development can be thought of. There has to be a united effort. Globalization, we must reckon, there is a fear amongst people that if we go a lot for globalization, perhaps the very concept of the dominions, concept of the sovereignty would be reduced to something which is not acceptable readily. It brings some uneasy friction between local and global, domestic and foreign, and perhaps local and universal practice. There is a need for a body of transnational law or global law which may be perceived as internationalization of law or globalization of law. There is a dialectic relationship between global and local law. I was just discussing it with my friend Mr. Desai, senior advocate who practices primarily on the international side. This can be better understood by appreciating the distinction between what we call the law of globalization and what happens to law when globalization occurs. The example in law of globalization would be contract law, which would require to be broadened in the new global scenario in comparison with family law, which can be allowed to remain untouched. In the law in globalization, the goal is to create an ecosystem which would cater to the growing global interactions between nations. Are we then looking at a unitary body of rules with universal application? I mean, that's the first question that confronts us. Or would it be necessary to address the multiplicity of legal systems and their interactions, which means acknowledging a pluralist perspective about the problems and its solutions? I would quote from Thomas Frank, his idea about globalization of law and how to deal with it, and why the international set of rules are being respected without there being any coercive system inbuilt in these treaties which are being followed by the nations. So he's one of the most celebrated international law scholars. He says that he conceded, actually in his theory about legitimacy of international law, he concedes that international law is not the law in the same sense as municipal law, but he admits of being heavily struck by the fact that without any coercive power behind most of the international law rules, many of such rules have very frequently been followed by many states. Why? He acknowledges that there must be something else which is responsible for such obedience. The factor responsible, according to him, is the legitimacy factor, which actually makes it justifiable, acceptable by nations, implemented by nations, and the municipal laws. The overall picture which has emerged today is that there should be emphasis for a robust international framework which can effectively respond to complex and interconnected challenges facing the global community. Who would deny that with the increased global connectivity, there is greater importance of trade and economic cooperation amongst nations? The World Bank, the IMF, the international trade system, all of this began as a general agreement on trade and tariff, which developed into a full-fledged World Trade Organization. This was post-World War II development, and this reflected Montesquieu's Dow commerce. Dow commerce, according to him, it has a civilizing effect. Civilized nations follow others. So this was one of the examples. The dispute settlement body of the WTO ensures that countries adhere to their trade obligations, thereby preventing trade wars and promoting economic stability. On the other end of the spectrum, away from economy, which is a conception of law, a global conception of law which deals with humanity as a whole. Now, one of the newer known scholar, Salem Hikmat Nasser, refers to it. He gives a very good name to it. He says it's an axiological motor of globalization, human rights, laws protecting human rights. So international law plays a very crucial role in preventing and mitigating armed conflicts between nations. That is what is really afflicting us today. The UN Charter prohibits the use of wars in international relations except in cases of self-defense or when authorized by UN Security Council. The international humanitarian law, as embodied in Geneva Conventions, they seek to protect civilians and combatants who are not taking part in the hostilities during armed conflicts. Another aspect, the global refugee crisis. This continues to be one of the pressing issues with millions of people displaced from their homes because of conflicts, because of persecution, and environmental factors. The 1951 Refugee Convention and its 1967 protocol provides a legal framework for protection of refugees and their rights. All this is international, all this is global aspect of law and its impact on municipal laws. One of the notable examples of such resolution at the international level is the verdict of the European Court of Human Rights in the case of MSS versus Belgium and Greece. I think all of you know about it. MSS was an Afghan national who had entered Belgium through Greece. And there it was found that the conditions, his reception was very bad. The conditions under which MSS was living, it was so bad that it required, intervention at the world level. So this judgment by ECHR, it has highlighted the responsibility of European member states to ensure human conditions for asylum seekers. Another very important case, Nicaragua versus United States, 1986. The ICJ, International Court of Justice, viewed the US support of Contra rebels in Nicaragua to be violative of international law, notwithstanding the supporters. Cybersecurity, as flagged by Justice Cole and Justice Trivedi, is yet another global concern. You're aware of a privately formulated Tallinn manual, though it has been formulated by people from all over the world without any official capacity, but it is accepted. It is accepted as a good manual, a vade-mecum for cyber security, cyber crimes, and its resolution. It has been produced by an independent group of experts, which offers guidance, and it is acceptable to all. not that it's true for only the nation which actually hosted this, where it was formulated. Now, beginning with SS Lotus case between France and Turkey in 1927, Suez Canal case in 1956, apartheid cases, Bosnian genocide case, the judgments of International Criminal Tribunal for former Yugoslavia between 1993 to 2017, all of this international law has helped resolve the crisis. Particularly E.C. Harmon's case, I think I must refer to it shortly, just to arouse your interest. As, one must know who the audience is. There are young children, young students sitting at the back. They must know what E.C. Harmon's case is. It has not been resolved as yet, but then it has led to some developments in the thought process, which is actually the purpose of globalization of law or globalization in law. E.C. Harmon's case, the dispute in this case was, it triggered when the European community banned the import of beef with synthetic hormones. Synthetic hormones were suspected to be affecting people's health. The ban caused the export from US and Canada to drop drastically. The dispute persisted for more than 2 decades. But one of the effects of this case was that US public opinion was awakened. Even though the tariff had gone down, the public in US, the opinion was not completely unsympathetic to European Union. The impact was that public in general got motivated to purchase organic or natural meats. It has not yet been resolved, let me tell you. But then the positive impact of it is worth noting. I would also like to refer to the massive proliferation of international institutions that have altered the traditional politics of interstate relationship. Responding to 9/11 attack, the UN Security Council has come out with a slew of resolutions which have developed into somewhat global system of standards, expectations, reporting and assessment, and seeking and demanding universal state action against acts of terrorism. You see what's happening in Canada. You see what's happening in US, what's happening in neighboring countries. Unless the world comes forward, the resolution would not be forthcoming as easily as it would if all of us strive together and not work in silos. The European Union has come out with a corpus of supranational laws in the field of agriculture, competition policy, energy, human rights, monetary affairs, public health security, and trade. International tribunals also have become centers for coordinating policies. Now, we must admit and not grieve that in this world, the coexistence and overlapping of different norms do not eliminate local distinctiveness. Talking about global law and globalization of law, we are not harping on something where one loses one's identity. The state law must be adaptive. There is always a somewhat unreasonable but lurking fear that with the diminution of traditional national borders because of transnational forces, the sovereign state may not be in a position to maintain the fiction of absolute sovereignty as well as its constitutional autonomy. I, for my part, strongly hold the view that globalization does not marginalize the state law. Rather, it makes the state law expansive in its reach. And then the UN Declaration of Human Rights, which talks about dignity, which talks about fairness, which talks about freedom of all fear, and particularly the freedom from want. That's what we are looking for. Climate change, again, is a global issue. There is greenhouse gases emission, rising temperatures, sea level rises, extreme weather events. We sitting in Delhi or in Patna, we only don't face this. The world is facing it. Because of the efforts of international bodies, many solutions have come to the fore which are being piloted and are being taken forward by nations. All this is the effect of globalization. Look at these efforts at transition to renewable energy, energy efficiency, reforestation, afforestation, carbon pricing, and collaborating globally through agreements like Paris Agreement, where it sets targets for reduction reduction targets for carbon emission and sharing the best practices. So after all, everybody's motto today, as Prime Minister also said today in the morning, one earth, one future, and therefore the globalization of law for resolving global issues. Thank you.
Mr. Vince Wilson, a senior counsel and member of the Rajya Sabha, will share his perspective with us.
Thank you, Justice Sanjay Kishan Kaul. Honorable Justice Sanjay Kishan Kaul, Honorable Justice M.M. Sundaresh, Honorable Justice Bila Trivedi, judges who have come to attend this meeting, distinguished speakers, guests, ladies and gentlemen, press and media, Vanakkam. It's my immense pleasure to join you for the Bar Council of India's International Lawyers Conference 2023, and a privilege indeed to address the first technical session alongside of honorable judges, eminent dignitaries, and my distinguished colleagues at the bar. At the outset, I thank the Bar Council of India Chairman, Mr. Manan Kumar Mishra, the Bar Council of India Vice Chairman, Mr. Prabhakaran, and all his entire team for giving me this opportunity to speak in this elite gathering. Friends, today I should have left to Uruguay, South America, in the four-member parliamentary delegation to attend the Second World Summit of Committees of Future Parliament, where we are going to deliberate on the global laws. And when Mr. Prabhakaran, at the instance of Mr. Manan Kumar Mishra, called me and asked me that I should participate, I requested my chairman, Mr. Jagdeep Dhankar, the Vice President of India, and he was so kind enough to postpone my trip alone to tomorrow morning in order to enable me to attend this conference. And he was so kind, and he inquired about this lawyers' conference. So I have to say this. Friends, human civilization is about to enter a period of profound technological advancement. The era of artificial intelligence is well and truly upon us. When such a civilizational transformation occurs, law has to keep pace with it. I think the evolution of law has had 2 or 3 such moments where it has been forced to evolve rapidly in response to a particular human activity. For example, when the internet connected the whole world, we had to strengthen legal framework to meet the challenges it brought. Industrialization brought with it challenges of environmental degradation. We had to address that issues through a global law because of the transboundary harm that pollution brings. Artificial intelligence technologies, including machine learning techniques and automated decision-making process systems, are expected to bring a wide array of economic and societal benefits in many sectors. Companies that are developing these emerging technologies have a responsibility to ensure their products are safe. These commitments, which the companies have chosen to undertake immediately, underscore 3 principles that must be fundamental to the future of artificial intelligence, namely safety, security, trust, and mark a critical step towards developing responsible artificial intelligence. The government has to have a draft policy guidance to ensure the development, procurement, and use of the artificial intelligence systems, safeguarding the people's right and safety. Friends, judiciary has started using artificial intelligence. I was present in Supreme Court when Constitutional Bench, headed by Honorable Chief Justice of India, was hearing a case. Honorable Justice Sanjay Kishan Kaul is also part of that bench. Chief Justice was telling Mr. Kapil Sibal, a senior advocate who was appearing for one of the parties, that all his arguments are typed with the help of artificial intelligence. And end of the day, it will be circulated among the advocates for their approval. That's how the artificial intelligence is now used in judiciary. Hereafter, you can't escape from the court after making your arguments. It will be recorded. Our new parliament building is adopting advanced artificial intelligence systems. Friends, India is a leading country in entire global in the field of artificial intelligence and is holding the presidential post in the Committee of Artificial Intelligence. Artificial intelligence is introduced in very many fields in India, in health, agriculture, and so on. However, the risk posed by these new technologies, especially for the human rights and fundamental freedoms, including with regard to the discrimination, data protection, and privacy, have to be deliberated. The laws on the artificial intelligence is different in each of the country. India is yet to legislate on it. Given the prevailing circumstances, the requirement of having a unified global legal framework has increased. International law can be nothing more than a set of basic universal concepts for the realization of the global legal rights. It cannot be a parallel legal system to nations' domestic law. Each country will have its own laws and ways of dealing with issues. So we cannot thrust on a country a system of law. But there are certain fundamentals we can ensure compliance. In areas relating to human rights, taxation, arbitration, climate change, banking law, we must come together to set a base from which nations can model their national laws. Take, for example, environmental laws. Sustainability, polluter pay principles, and intergeneration equality must be the key philosophies that form the basis of the laws of all countries. In arbitrations, we must do more to ensure smooth enforcement of foreign awards in all jurisdictions. That is the key to success of international arbitration. I am sorry to say that in India, we have not yet come to a stage where we can enforce foreign awards with the speed and zeal that is required. Often, courts sit in the judgments over the foreign award. Foreign awards are always looked at with suspicion. There is a feeling as if we lose the superiority of Indian laws and courts if we enforce foreign awards. That has to change. Similarly, when it comes to anti-suit injunctions granted by the foreign jurisdictions, it becomes a question of us versus them. It has somehow become a question of dominance. It should not be looked at through the lens of how can a court or a tribunal in London or a Singapore injunct an Indian court. We should instead look at these issues as if the global legal system is one interconnected mission where each part is doing a separate job. If we enforce foreign awards efficiently, our awards and orders will be followed and enforced in the jurisdiction. That is also key to make India a hub for arbitration. You will be aware about the mediation laws, and in fact, the entire judiciary has cooperated for bringing this mediation laws. And I would thank our Honorable Justice Sanjay Kishan Kaul, who has played a key role in helping us to shape the law. I would also like to focus today on the emergent need of a strong, predictable, reliable, global framework for preventing human rights violations of minorities and safeguarding their rights through effective implementation of anti-discrimination laws. The pressing issue among all issues is the human rights violation across the world. Even though UDHR has inspired a rich body of legally binding international human rights treaties that continues to be an inspiration to us all in addressing injustices, in times of conflicts, either cross-boundary or within territory, we have witnessed gross abuses. Time has come where all states must stand in solidarity against such human rights violations happening in any part of the world. A glance of multiple reports released by the UN would reveal that the worst sufferers of the human rights violations are the minorities of the world. The term minorities refers to the members of the four categories, which are national, ethnic, religious, and linguistic minorities, as set out in the declarations on the rights of persons belonging to national or ethnic, religious, and linguistic minorities. The right to equality and non-discrimination is at the heart of the minority rights. The realization of the rights of national, ethnic, religious, and linguistic minorities necessitates effective protection and fulfillment of the right to non-discrimination. As such, the enactment, enforcement, and implementation of a comprehensive anti-discrimination law is essential if states are to fulfill their obligation to respect, protect, and fulfill the rights of minorities. The prohibition of discrimination inheres within minority rights. All states must ensure that all aspects of the right to non-discrimination are effective in their efforts to guarantee minority rights. This includes ensuring the laws, policies, and practices do not discriminate directly or indirectly against members of minority communities while enabling them to enjoy their cultures, professing or practicing their religions, or use of their languages. We understand that finding a uniform baseline for individual freedoms is tough across the globe. Each country's society, culture, and traditions dictate their interpretations of freedoms. However, we must all understand in today's global civilization, the right to free speech, movement, marriage, self-determination, sexual orientation must be inalienable and guaranteed. States do not meet their international legal obligation by simply defining and prohibiting discrimination. They must also, among other things, adopt positive measures designed to accelerate progress towards equality for those subjected to historic disadvantage or otherwise unable to participate on an equal basis. States' effort should include and go beyond countering prejudice, stereotypes, and stigma if they are to uphold their commitments and keep their promises to end discrimination and ensure equality of participation. The emphasis should be on actively fostering equitable, varied, and inclusive societies, as well as aggressively combating harmful social forces. Similarly, I feel India needs to strengthen its banking laws to keep pace with the global trends of cryptocurrency and blockchain technologies. Right now, we have stopped with the taxation of these transactions. I foresee that in the future, these types of currencies will become mainstream in other countries. We must put in place the foundational building blocks now itself so that we are not caught by surprise at a later point of time. I don't think there is any use in resisting technological advancement such as these because they will inevitably grow. I once again thank the Bar Council, Mr. Manan Kumar Mishra and Mr. Prabhakaran for having given me this opportunity, and I look forward to hearing the other speakers and panelists throughout this conference. Thank you very much.
Thank you, Mr. Wilson. I would now request Ms. Lubna Shuja, who is the President of the Law Society of England and Wales, to share her thoughts and ideas. She indicated she would like to...
I'll do it from here.
Are you comfortable there?
Fine, yeah.
Okay. Then you can address from here. Thank you.
Thank you. Thank you very much. Thank you, Honourable Mr. Justice Cole. Good afternoon, everyone. Can I start by saying a big thank you to the Bar Council of India and particularly to Chairman Mishra for inviting me to speak at this inaugural conference. It's an honour to be here in such esteemed company and on this panel with such distinguished speakers from the judiciary and from the legal fraternity. I also want to thank the Bar Council of India and the Indian government for their progressive approach to working to foster collaboration in the legal sector. As you have just heard, my name is Lubna Shuja. I'm the president of the Law Society of England and Wales. We represent, we support and we protect the solicitor profession in England and Wales. We have over 200,000 members who are based in the UK and around the world. This is my second trip to India as president of the Law Society, and it is a great privilege to be here again to build on cross-country relationships. At the Law Society, we engage regularly with the UK and Indian governments, as well as with the Bar Council of India. to promote cooperation, to promote knowledge sharing between our two jurisdictions. This relationship is important to the legal professions, both here in India and also back home. UK and India already have very strong ties in numerous areas, such as trade, our laws, and of course, culture. Who doesn't love a Bollywood film with Amitabh Bachchan in it? Who doesn't enjoy a good masala dosa? And we even have a Prime Minister of Indian heritage. The UK remains a welcoming destination for Indian business. For many, many years, our jurisdiction has been open to Indian lawyers and Indian law firms. The timing of this conference is an excellent opportunity for us to reflect on the merits of a globalized legal sector, given the ongoing UK-India Free Trade Agreement negotiations. Closer ties through trade deals and a strong mutual understanding of the importance of international law can help all of us to address the global challenges that we face. Worldwide issues require a coordinated response. As lawyers, even though we come from many different jurisdictions, we are all connected. We are united by our common respect and commitment to justice, by our desire to safeguard the rule of law, and by our duties to the court and to our clients. These shared values give the legal profession its long-standing, strong reputation. All of us are bound by the highest ethical standards, and they are enforced through principles which are contained in a strict code of conduct. But our world is changing, and we've heard already about new technologies, we've heard about new issues which are throwing up unique ethical challenges for lawyers. This is where collaboration across jurisdictions is absolutely vital. The public must have faith in our legal systems and must trust the lawyers that they use. But those lawyers are finding more and more that they have to deal with constantly evolving concerns. Public attitudes, as well as media rhetoric, is constantly changing, sometimes in a matter of days, sometimes in a matter of weeks. Lawyers are increasingly having to work out, how do I deal with public opinion when it's impacting on my clients and on my business? Others have already spoken about climate change. This is a key global challenge. And in this context, we are seeing ethical issues for lawyers. Lawyers who are being criticized for acting for particular clients who may not be climate friendly. Lawyers' own carbon footprint is under scrutiny. The Law Society of England and Wales recently published the very first world-leading guidance for solicitors on the impact of climate change. And that guidance is available on our website for anybody who wants to have a look at it. Lawyers all around the world need to be aware of the potential consequences that concerns like climate change can have on their organizations. Our guidance covers concepts like greenwashing, how physical and climate legal risks might be relevant to legal advice that you are giving to your clients, and how lawyers can meet their own ESG aspirations. Cybercrime is another challenge that knows no boundaries. Client confidentiality and the potential loss of large sums of money are at risk every day if lawyers and law firms do not have robust systems and processes in place. In the UK, we recommend law firms should ensure they have cyber insurance in place to protect their businesses and their clients. Another global issue that we're dealing with, and again, we've heard a great deal about this already, is artificial intelligence. That is not currently regulated. Almost every solicitor that I speak to is worried about ChatGPT, and I'm sure many of you in the room know about ChatGPT. We know that there are law firms using ChatGPT to research case law. We also know that a law firm in New York used ChatGPT for research and relied on a case from ChatGPT when making submissions to the court. Despite ChatGPT providing a full case name, a citation, and a very detailed judgment, it turned out that the case that was mentioned in court in submissions did not exist. The firm that used that case was fined. In the UK, we are calling for the regulation of AI, and our government has recently consulted on this issue. And it's not just about the reliability of AI, but also the inherent biases that may be present in AI processes. So we have to proceed with caution when we rely on AI, because ultimately, the lawyer is responsible, not the machine. During my time as president, I have focused on professional ethics, and we have recently launched a professional ethics hub on our website to support members. Turning to international cooperation, I have been really proud to be part of the ongoing international cooperation between the UK and India. The current trade negotiations create an opportunity for our legal professions to benefit from each other's jurisdictions. In England and Wales, we have an environment that is open, a legal environment that is open to lawyers from all over the world. We are proud to be home to legal professionals from nearly 100 jurisdictions. We have over 200 foreign law firms based in the UK. This openness to international talent has helped to turn our country into a global leader. Our legal services sector adds £60 billion to the UK economy every year. It includes skills and expertise on foreign jurisdictions, which is not otherwise found domestically in the UK. The sector supports greater consumer choice, business outcomes, and economic growth. This means that clients can instruct lawyers in the UK who are able to advise them on foreign laws. Those clients don't have to take their business outside the UK to find the expertise that they need. Critically, this has supported investment coming into our country. International companies have greater comfort when they invest in countries where they can access legal services that they need using the lawyers that they are used to working with. Many Indian lawyers in the UK can work there without having to requalify. They can practice any area of law other than a small number of reserved legal activities, such as advocacy, conducting litigation, probate, and transfer of property. Those are the only things that Indian lawyers cannot do and foreign lawyers cannot do without qualifying as English solicitors. The English and Welsh legal community highly values the contribution that Indian and other foreign lawyers make to our profession. We are committed to making sure that we remain an open jurisdiction. There is no reason to believe that India could not enjoy similar success as an open jurisdiction in the future. The recent G20 summit showed that India is open for business. Your country is becoming increasingly welcome to foreign organizations and investment. Now is the time for both of our countries to engage around win-win opportunities to benefit our businesses, our citizens, and our economies. Today gives us an opportunity to celebrate the Bar Council of India's rules and regulations on foreign lawyers and foreign law firms operating in India. I want to reassure all of you that English and Welsh lawyers have no intention of taking your court work away from you. They will not practice Indian law. They are only interested in international law, cross-border work, and arbitration. They want to have an office in India so that they can provide advice on foreign law to their clients who have interests in India. Now, a lot of that work is already happening. It's already being done, but it's happening outside India, in places like London, like Dubai, and like Singapore. The new regulations will allow this work to remain in India, where it will benefit your economy as well as grow your profession. And that takes me into another global issue: developing our next generation of lawyers to meet worldwide challenges ahead of them. We must give hope and opportunity to our youth on both sides, as through them we build the world of the future. There's still work to be done to turn the regulations into a practical reality. English and Welsh firms are keen to work with and alongside Indian law firms and Indian lawyers. They want to offer you opportunities to work together for the benefit of all of our clients, whether that's through referral on areas of Indian law or through employment and partnerships. We know that working with local lawyers is critical to foreign law firms because local lawyers understand how things work on the ground here in India. The Memorandum of Understanding signed earlier this year by the Law Society of England and Wales, the Bar Council of India, and the Bar Council of England and Wales was a very positive step in the right direction. That memorandum will be of great value to each of our organisations. It will help to jointly address any challenges or obstacles to our shared ambition. At the centre of the Memorandum of Understanding is a commitment to the rule of law, as well as to the principles of integrity and access to justice that each of our organisations stand by. I am very grateful to the Bar Council of India for organising this conference. We have many distinguished speakers still to hear from, and I look forward to hearing from them, as well as speaking to many of you during the course of the conference. Let's work together. Let's work together and learn from each other to address the global legal challenges impacting on all of us. Thank you.
Learned Senior Counsel to share his thoughts. Yes, you. Whichever way you are.
We're not used to be sitting and talking and delivering, right?
You're most welcome.
You still have the appetite to listen to me? Are you sure? Okay. Nobody leaves this hall until I finish. I have been given 7 minutes, but Indian law Indian stretchable time. No problem? No, don't worry. I'm not going to too much time. First of all, I'm so excited and I think very privileged to be in the midst of August panel here. I think I would not name everybody and take time out of my conversation, but everything that one would want to hear has been said. So now what I want to do is to share a little experience and share some thoughts and share some ideas, okay? That we are in the new world today. We talked about globalization at one point of time. I specialized globalization in 1977. At that time, we were all talking about Indianization. There was no taker for my work, so I had to develop practice, most of which evolved in the US, and some of the other practice grew for almost 10 years. Again, I practiced only Indian law, okay? They are very strict in the US. Even small mistake here and there can cost you enormously, okay? And sometime in 1980, I'm a counsel. In India, counsels don't set up law firms. In 1985, there was a Wall Street banker who suggested me that why don't you set up a law firm? So I said, why should I set up a law firm? It's nice life, free life, you know, solo and no hire, fire, all this kind of thing. But then I thought, let me study how these firms have become so large, so powerful, and they were all very small firms until 1950s and 60s, 70s even. Suddenly they grew very high. Because accounting, first of all, bankers became bigger and bigger. Accounting firms followed bankers, okay? And then law firms began to follow accounting firms. So craze for growth was getting bigger and scale up and all that. So scale up was the mantra, but scale up was meant to be sizing up. Like growing fat is different than scaling. Scaling up is going from this level to this level, okay? Sizing up is bigger. Anyway, I learned a lot in studying about 100 professional services organizations, including law firms, accounting firms, consulting firms. And after that, I was wondering, I'm a solo practitioner, what do I do? How do I compete? What do I do? When I looked at their history, their 100-year history, 200-year history, I have no history, what can I do? After a lot of thinking came up that an idea came that, if they can look back 100 years, I can look forward 100 years. And when we are resource-starved, you are more creative. So what happened, and I'm a researcher, so what I thought, let me look at what are the things that are going to happen in the future, visualize today the problems of the future, be prepared for that, so when time comes, we can deliver our services in the shortest period of time with smallest teams, because they're already prepared. Otherwise, law firm model is very, very bizarre, that if you spend more time doing client's job, if you put more people on the job, we are more rewarded. Actually, it should be less time, less people, but you can do only if you have worked ahead of time. So philosophy came up that every new technology, every new business model, every new social, political, economic development brings along with it a new strategic, legal, tax, or ethical issues. Okay? Our role has already been automated as far as compliance is concerned. Next 5-7 years, you will have smart contracts, transactions will be automated with blockchain technology and stuff like that. But more important role will evolve into ethical issues at which India is extremely good. That is our positioning. We will be good at crisis management. We always work in chaos, okay? And we are very good at jugaad, but I think we have to become innovative now. I believe, in fact, so, I started looking at, new technologies that are going to come, hired some engineers who came up. I turned them into lawyers who will come and join me. Anyway, social scientists and stuff like that. I'm just not going to bore you with too many stories. But idea was to put together a team which was not just lawyers, but lawyers with other background. If you have only people in other background, they will not understand the ethics. We still are little old style thinkers that we are in the profession of law, not in the business of law. Okay? So we have to imbibe that in the kind of thing. So anyway, so look to the future and prepare and write a lot of papers. In fact, I would have presented some 70 papers that we have written on the futuristic technique, like ChatGPT, which is coming up, the smart metering, to flying cars we specialize now, because these are all the new areas which we have to really work on. Because there are three sets of kal, aaj aur kal. There are global problems of the past, which are still sitting and litigated. Second, new problems are coming up, many of them you mentioned about. Like, I personally feel that immigration is one of the most important law that we need to internationalize. There is no standard. It is a worst form of protectionism and against human rights. Every human being has a right to prosper. It's part of the human rights as well. Number two, that as far as immigrations are concerned, that is being used as a tool to, not allow other people to come in. We have offices in Silicon Valley, in New York, in Munich, Amsterdam, Singapore, everywhere I have seen there are a number of different things that you need to face, but we can do it. You won't believe that in 10 years' time, we are ranked as the most innovative law firm in whole of Asia, and almost not 1 year for 5 years, okay, by Financial Times of London. So we can do it. What I want to tell you today is that if we position ourselves right, we have excellent talent in India. All that we need is organizations that can nurture the talent. So let us build organizations. Don't need to be big, not to have very, I think, esoteric thing, but really put heart. We can compete anywhere in the world. Second thing I found, there is huge opportunity to contribute among the small economies. I was listening to the president of, what is it, near Indonesia, I forget that country. And he said, no consultant is coming to advise us. You know, it produces world's best coffee. Okay. So, thing is that then Uzbekistan I have gone, many other countries we have gone, Mauritius, we develop entire financial sector there. So, in lighter vein, Prime Minister of Mauritius once said that 13% of Mauritius' economy is because of Nishi Desai. Okay. In fact, we developed Gift City later on. I had given Gift City idea in 2007 to Mr. Modi. It happened. We can do it. Singapore we have helped. Why not? If you ask me, when the British came, they gave us a better law than what they had. It was all unwritten, precedent-driven and whatnot, right? They codified, they improved on it. Just like if you go from an old house to the new house in society, you do a better job. They never thought India will leave. You know, so British gave us better law than what it was. Indian law was already internationalized. In Singapore, Malaysia, Aden, Burma, you see same sections, almost same sections, right? Even 420 is section 420, I believe. Of course, all law is changing the number now, so I don't know what that number is. I'm sorry, I'm going a little long, but my point is that our law has already, has been global, and we can do it. I think with that spirit, we should do it. There are, you know, as Lubna mentioned, that, you know, the Indian law practice and foreign law practice and all that, that's all there. But I think if we really focus on what is the next, you know, you'll do a lot of things. There are a lot of activities that can be possible. We will prepare for the future. That is where our future is. And I don't want to take too much time today, but some point in time, we have more time, most welcome. And we have a research campus in Mumbai, most welcome there too, where we do most of the research on the international law. And I'm grateful to you for the patience and sorry for depriving you of lunch for 10-15 minutes. Thank you.
Thank you, Mr. Desai. Mr. Agarwal, the President of the Supreme Court Bar is there. He would like to have a couple of minutes to say something.
I am delighted to be associated with this international conference, and I actually congratulate that our Chairman of Bar Council of India, Mr. Manan Kumar Mishra, and Vice Chairman, Mr. Espar Bhakran, they have organized this international conference. This is the first time that the Bar Council of India has organized. When I was the member of Bar Council of India, that time in 1998 or 99, Bar Council of India organized national conference on electoral reforms. That is, that time the government was of Mr. Atal Bihari Vajpayee. Today the government is of Mr. Narendra Modi. There is a difference. That time it was Arun Kumar Mishra who later became the Honorable Judge of Supreme Court of India. So both Mishras, my lord, they first Mishra organized national conference. Later on, other Mishra organized international conference where all judges, senior judges are present. That time, Atal Bihari Vajpayee was the chief guest. Today, Mr. Modi is the chief guest. So, this is unique. At that time, there were talks with Bar Council, Law Society of England and Wales, and today, the President of the Law Society of England and Wales is with us. The Lord Chancellor of dealing with the justice was also here with us. And that time our delegation went on behalf of All India Bar Association and Bar Council. And today, under the leadership of able leadership, Mr. Arun, our Manan Kumar Mishra, we are completing those talks. And today the President of Law Society of England and Wales has clarified that they don't want to practice Indian law. That was our demand, and under the leadership, Honorable President of Law Society of England and Wales, rest assured, the all lawyers of India are under the umbrella of Mr. Manan Kumar Mishra. And whatever you have made statement, that will be adhered to. Whatever the statement made by our Honorable Chairman of Bar Council of India, that will be adhered by every lawyer of India. And the Government of India, under the able leadership of Mr. Narendra Modi, they are ready to do everything which is good for the people, not only of India and UK, for the entire world. Today, we are discussing on this issue, global law for global issues, international legal solution. In 2012, when we were having international conference on terrorism in London, Justice, our Lord Phillips of Worth Matter Awards, and the President of International Court of Justice, who was from Russia, Mr. Peter Tomka, all judges, all lawyers, all law teachers who attended that conference, that was one thing, they were unanimous that today international terrorism is the main issue which is to be tackled. That is the real issue which all the judges, lawyers, they have to tackle. And they have to ensure that law of the different countries should be as such that we can control the international terrorism. That is the main issue. If we are able to tackle international terrorism, then everything will be solved, and that is the reason I'm the last speaker. I'm the extra speaker, because one of our Honorable Chief Justice could not attend. So when I am getting special patronage from Bar Council of India because I worked earlier as Vice Chairman. So today I'm happy that I have the opportunity of adopting all the issues which my earlier speakers have raised. I am really thankful for providing this opportunity, and the jurists, the lawyers and the judges should come forward to control the international terrorism. Our Prime Minister also, our Chief Justice of India also, our all judges also want that there should be control on international terrorism. Thank you very much.
Well, we had mentioned about a question and answer session, but I really don't think I want, you would like a question and answer session on empty stomachs now. You have another session at 2:30 here, and you will need some time to have your lunch. What we are proposing is that if any of you have any ideas emerging from discussion today, a note can be sent to the Bar Council of India, and we'll get an opportunity to examine the same. Thank you all very much for being such a patient audience. And thank you to the panelists. I now hand you over to the Vice President.
Thank you. The valuable discussions went on more than an hour. Really extremely good. Now I am request Mr. P.S. Amalraj present a memento to the Honorable Justice Sanjay Kishan Kaul. And next, Mr. V. Karthikeyan be ready. Divya Roy. Yes. Google. Present a memento to Honorable Justice Sanjay Kishan Kaul. Chairman Bar Council of Tamil Nadu, and Mr. V. Karthikeyan, present a memento to Honorable Justice M.M. Sundaresh, is the Vice Chairman of the Bar Council of Tamil Nadu. Mr. Vidudalai, former Advocate General of Tamil Nadu, present a memento to Honorable Mr. Justice Ashutosh. Mr. Srimali. Memento. Mr. Srimali, present a memento to Honorable Mr. P. Wilson. Wait. Madam Misrila Pandian. Honorable Justice Bellayam Trivedi. Mr. Misrila Pandian, Executive Chairman of the Bar Council of Tamil Nadu, present a memento to Justice Bellayam Trivedi. Good. Mr. Apuru Kumar Sharma, present a memento to Honorable Mr. Justice M.M. Sundaresh. चल जाओ M.M. Sundaresh. Honorable Justice M.M. Sundaresh. Next one, who has to give? Mr. Dilip Patel, present a memento to Honorable Mrs. Lubna Shuja, President Law Society of England and Wales. Mr. Dubey, present a moment to Nishit Desai. Come, Dubey, come. Come, sir, come first. Mr. Dubey. Nishit Desai, Senior Advocate, Bombay High Court. Now I request Mr. Vishnuvardhan Reddy give a vote of thanks.
Speech is power. Speech is to persuade, to convert, to compel, as said by Ralph Emerson. Sir, today your thoughts have enlightened our minds and have shown us a new path. My gratitude to all the speakers for gracing this occasion, sharing their opinions today, and particularly today, the chairman of the session, Honorable Justice Sri S.K. Kaul, the senior most judge, Supreme Court of India, co-chairman of session, Honorable Mr. Justice M.M. Sundaresh, Judge, Supreme Court of India, Honorable Justice Bela M. Trivedi, Judge, Supreme Court of India, and also the excellent speakers, Honorable Mr. Justice Ashutosh Kumar, Judge, Patna High Court, Honorable Mr. Justice P. Wilson, the Senior Advocate, Member Parliament, Rajya Sabha, Honorable Mrs. Lubna Shuja, President, Law Society of England and Wales, UK, who is an Indian origin, and also Mr. Nishit Desai, Senior Advocate, Bombay High Court, Desai and Desai. Sir, today, the Bar Council of India, its Chairman Chief Manan Kumar Mishra and Vice Chairman Mr. Prabhakaran and the Bar Council of India members and entire the legal fraternity of the country, we extend heartfelt thanks to all the guests and the speakers for enlightening our minds on the topic global law for global issues and international legal solutions. Certainly, sir, your speech has inspired us. We will be the torch bearers. The lawyers will be in the forefront, will carry your speech, message and ideals for the next generation and the future world, particularly for the peace, mankind, and the welfare of humanity. Thank you, sir, for participating and also giving the valuable speeches. One more announcement. Session 4, which is scheduled to be held in hall number 6, will be held in this hall from 2:15 to 3:35. So, meanwhile, that the lunch break. And we request the BCI members to come for the group photo. Honorable members, Bar Council of India.